So the question was, I talked about on the slide here, you can see a moratorium approved in April, in early April. And the question was, who approved that? The Board of Supervisors are the ones that approved it. The Board of Supervisors are the only ones that have the authority to pass a moratorium. Now, it could be recommended by the Zoning Commission that a moratorium be enacted, but a moratorium is an act that is reserved to the Board of Supervisors. And the Board of Supervisors did it through a resolution. And so via resolution, they went through the whole process of drafting the resolution, having a public reading of the resolution, and then ultimately voting on that resolution. And I'll paraphrase the resolution. I think there's like 4 or 5 paragraphs of it, but it essentially cites the fact that we have these issues with the project over at Deer Creek and Grove, and that we know that our ordinances are out of date, and we know this is going to take some time in order to update these, and we think it's going to be necessary to update these since we know that there's more projects coming down the road. So we're going to pause on processing any applications for wind turbines until after we go through this process of reviewing and determining what changes are necessary. And then they gave an automatic sunset of July 1st of 2022 that moratorium would be lifted. It did come close in June when they were reviewing the wind ordinance. Normally, for an ordinance, it goes through 3 public readings, right? Well, the supervisors had their first public reading. Their second and third public reading, in order to approve it, would have happened in July after the expiration of the moratorium. So they discussed extending the moratorium until after they did that. But when they came to the first public reading of the ordinance, there were 4 people, 5 people in the room saying, "Thank you for finally doing this." One person spoke up out of the 4 that were there saying, "Thank you for finally doing this." And so the supervisor said, "Well, if that's all the public comment that we have for this new wind ordinance, then we could probably waive the second and third reading," which they did, and then approve it. So they didn't have to extend the moratorium after all. Yes?
I'm very frustrated being on this commission because they're trying to put together a meeting and I don't have support of the commissioner because of the supervisor litigation. I don't have support of the supervisor because of the litigation. Some of the zoning board members have raised their litigation.
Okay, so,
Hear this tonight.
yeah, so, and again, that's why that's why, as I said, I think it's unfortunate that we don't have more of those folks here tonight. So the question, comment rather, was essentially voicing frustration of being able to get these zoning commission meetings going. So I presume you're a zoning commissioner, but not the chair? Okay, so any member of the zoning commission can petition the chair and say, "I want to add XYZ to the agenda." And then the chair would have to schedule a meeting and go through, that agenda item. These issues are the responsibility of the zoning commission. That's when you read the code about the duties of the zoning commission, that's the duty of the zoning commission to make certain that they're making recommendations for what they believe should be in place for zoning rules in the county. The zoning commission's job isn't to just adjudicate changing this land from this zone to that zone. The responsibility is to maintain the ordinance. And those recommendations originate at the zoning commission, go through the zoning commission process to develop the changes. You have to have a public hearing when you say these are the changes that we've agreed on as a commission. And then once you've had that public hearing, whether you take action on what was voiced in the public hearing or not doesn't matter. You don't have to do what it is that the public, that people say during the public hearing, but you gotta have the hearing and consider what's being said. Ultimately, the zoning commission then votes on it and sends the report to the Board of Supervisors, and then they're required to take action.
So we don't need a public hearing to meet and discuss, we're not gonna make changes.
No. Now,
That
the,
becomes clear in our,
yeah, so the zoning commission meetings, because they're a government body, the zoning commission meeting is open to the public. So just like you can sit in and watch a supervisor's meeting, you can sit in and watch a zoning commission meeting. But the zoning commission meeting is just the 5 zoning commissioners sitting around a table discussing whatever's on the agenda. And if what is on the agenda is we need to make changes to these things, or we want to recommend a moratorium so that we can take the time to make these changes, because it is a long time, it's a lot of work. And so a moratorium makes sense. And so you just have to tell the zoning commission chair that I'm a zoning commissioner, I think we need to talk about this stuff, and I want to have a meeting so that we can talk about it. And once you've talked about it, you make the motion. If somebody else seconds the motion, we have the vote. And if the vote is yes, we're going to work through this stuff, then you started the process. Now, if the 3 out of 5 zoning commissioners say no, we're not going to, we're not going to do this stuff. If you get one person that seconds the motion, but it still fails on vote, well, then you're kind of screwed until you can convince at least one of those members that they need to move forward. But one of the things that they shouldn't be is scared of this legal action. This notion that an energy company or some other lawyer sends you a letter and says, there's another case over here with the Board of Supervisors, so we don't think that you should be having any zoning commission meetings to talk about this stuff because that's going to interfere with our case. Caca. It's not. It's 2 separate things. Your zoning commission, you are obligated by law to maintain your zoning ordinances. That's your job. What the supervisors did, didn't do, will do, won't do, what their court things are, is completely independent of your zoning commission responsibilities.
Quick question. In June, it says that you guys had a public hearing and a vote approving the ordinance. Was it a public vote or was that a vote of the Board of Supervisors?
Right, so our process with the wind ordinance, so we had a draft ordinance that we published to everybody. We actually sent copies to anybody that had given us input. And then we scheduled a public meeting a couple of weeks later, where a forum much like this, where the zoning commission sat out front on the tables and said, okay, who's read the draft ordinance? What comments do you have? And we told everyone we're going to stay here until we've heard from everybody. That was the public hearing. That's what the zoning commission did. Then we went back, we made some changes to our ordinance. Then we voted on that draft, and that was the draft that we gave to our county supervisors and said, this is the unanimous, this is the ordinance by unanimous vote of the zoning commission that we think you should vote on. The Board of Supervisors then, in order to pass an ordinance, they have to have a public reading, first, second, and third public reading. Where in a supervisor's meeting, it's known on the agenda that this ordinance is out there, everybody's had a chance to read it. And in that supervisor's meeting then, the public has an opportunity to comment on that ordinance. And if they don't get very many comments, then the supervisors can waive the second and third meeting, or the second and third public reading. But if they get a bunch of comments, they can have a second and a third public hearing, or public reading rather is what it's called. And it's during the supervisor's meeting.
Okay, then not a question, but just a comment. I understand the gentleman's frustration on the zoning board, and here in Tama County, I think that they've made it evident that they voted unanimously to reaffirm the current existing ordinance. And in Tama County, it appears to be outdated and needs to be readdressed, and at a minimum, a moratorium needs to be put into place. We have a saying in politics that goes something like this: personnel is policy, and our Board of Supervisors is the one that needs to be held accountable. There's an election coming up in November, and we really need to be, as the citizens of the county, making sure we understand where people stand, the ones that are running for our votes, and make sure that we all get behind and support the person that's going to support our rights.
I agree 100%. And again, I will say that I know that there is legal action in the courts right now with regard to the supervisors having voted to reapprove the zoning ordinance. The court's going to hear that case, and the court's going to decide. I can tell you, Jeff Gorbel's non-attorney opinion is that the supervisors violated the statutes that talk about how they're supposed to do these things. Because as soon as this ordinance comes up for vote in front of the supervisors or by the supervisors, question one should be, did that come to them by way of zoning commission? If not, it should get sent to the zoning commission. Because these things, the statute said the recommendations come through the zoning commission. Number two, if they are going to say we're going to reapprove this, whether they're reapproving, approving new, approving a change, it's a new ordinance. And a new ordinance requires public reading. Again, that's according to Iowa statute. I don't know how the courts are going to rule it. That's just Jeff's non-attorney opinion. But based on Jeff's non-attorney opinion, I would tell you, if I were on the zoning commission down here, I'd be having zoning commission meetings talking about, do we need to make a formal recommendation to our supervisors to enact a moratorium, because it's going to take us a boatload of time to take this on, to make changes to the ordinance that we know need to be changed.
Does anybody have any note cards they want to pass in for us to read a question, or, do you want me to read it?
Go ahead and read it, Deb.
Can you explain the words parcel or acres or number of turbines each person signs up for?
I don't know the context of the question. To me, a parcel would be a collection of acres that is legally defined and identified under a parcel ID in the county land records, and should be available on the county GIS or at the assessor's office. And what was the other part?
Or the number of turbines each person signs up for.
The number of turbines each person signs up for? However many they want. The reality is, if I'm a landowner and I've got 160 acres or I've got 2,000 acres, if I want to sell my wind rights to an energy company, much in the same way that my great-grandfather sold the mineral rights to his property, an oil company could come in tomorrow, if it hasn't expired, I think it probably has, but an oil company could come in tomorrow and start drilling on land because my great-grandfather sold the mineral rights to that land. Well, if a landowner wants to sell their wind rights on that land, on his land or her land, that's their prerogative. Now, as far as how many turbines go on that land, that's up to the energy company. Because one of the things that these easements, I gotta say, if you're a landowner considering signing these easements, by all means, take it to an attorney. There's no way I would sign the easements with the language that's in there right now. But understand, it doesn't matter what that land agent tells you. What matters is what's written in that agreement. And we had a lot of landowners in Worth County that almost fell over when they found out what was really going to happen. We have landowners in Worth County that inherited land from a parent that passed away in the past couple of years that sold the wind rights, that they were planning to build on that property, and the wind company says, no, you shouldn't build there because we're going to put a turbine there. Well, no, that's my land. I want to build the house. You guys put a turbine over on this other spot. No, we'll determine where we're going to put the turbine. You sold the wind rights. We'll determine how many turbines are going to go on the property and where those turbines are going to go on the property, and we'll pay you per turbine according to the terms of the other agreement. That's how they work. What other questions?
Okay, these people that are all signed up to have a turbine, can they get out of it?
So the question was, the people that have signed up to get turbines, can they get out of it? So first of all, words mean things, and so I want to clarify a couple of things. So first of all, people aren't signing up to get wind turbines. What they're doing is they're selling their wind rights, and they are waiving, as a part of selling those wind rights, they're waiving wind effects. These agreements talk about shadow flicker, they talk about noise, they talk about safety issues. And when you sign these easements saying, I'm granting you wind rights over my property, I'm waiving the effects of your use of these rights. Once you've signed away those rights, the energy company then say, okay, we've got all of these acres that we could use. Which ones are going to make sense for us to use? And then they'll determine where they want turbines to go. And that's why you may end up with a turbine on your property, you may not. You may wind up with 3 turbines on your property. You don't know. And you don't have control over it. But what the energy company will do, in that first agreement, when you sold the wind rights, you're also saying, I'll sign another agreement that talks about how much you're going to pay me per turbine if you put a turbine on my property. But that's a separate agreement. That when they actually decide they're going to put a turbine on your property, that's a separate agreement. It's going to have separate payments. And that's where they're going to pay you year after year after year for as long as that turbine is there. The wind easement is just, that's a one-time payment. Now, the land agent may tell you, we're probably going to put X number of turbines on your property, and here's how much money you could make. He doesn't know. They've not made their plan yet. They don't know where those turbines are going to go. They're just trying to get as many people signed up as possible so that they can look at all of this land and say, we got enough land to make a viable project. Let's figure out where we're going to put them.
My question is, how can a farmer get out of the easements?
How can you get out of the easements? Find a good attorney. It's hard, but it's going to take an attorney. And I know it can be done. I know there's the attorney in one of the attorneys in Worth County, Doug Kroll. I know he got a couple landowners out of their easement.
I know when they approached me twice, and I asked them, where's this turbine going? So Nan can't tell you. That's probably the reason why. They could choose any part of my land.
That's right. You don't get a say. Once you sign the easement, you sign the rights for them to put up a turbine anywhere on your land. And it's up to them where they put it.
Right. I told them no. I took that contract, it's about that thick, to my lawyer, and my lawyers told me no.
Yeah, that's good.
Yes.
Yeah, I would never sign it. Yeah, just to give you an idea, I mentioned this to the folks earlier tonight. I read some of these easement agreements, and I don't know if this clause is in all of the ones or in any of the ones that are happening down here in Tama County. And I wish I could remember the name of the legal doctrine. I think, is Mike Youngblood still here? Perhaps you know what the name of this doctrine is, but there's a legal doctrine that essentially says if there's a clause in the contract that could be interpreted 2 different ways, the court should interpret the clause in the way least least advantageous to the person that drafted the agreement. And the reason that's there is if I'm going to draft a legal agreement and I'm going to ask you to sign it, that doctrine puts the onus on me to make sure that this language is clear. Because if it ever goes to court and there's a clause that is ambiguous and it can be interpreted different ways, I'm going to be disadvantaged because I wrote it. And so it's there to protect people. I don't recall what the name of that legal doctrine is, but I saw easements in North County where the energy company explicitly called out that doctrine and said that doctrine shall not apply to the terms of this agreement. I don't think landowners knew what they were signing when they signed it, but they were effectively saying, if there's something ambiguous in here, yeah, take the energy company's side, not mine.
I've got one handed to me. It says, it sounded to me that you said if the commission, whether they make changes or not, if they are satisfied with the ordinances, they need no public meeting to inform them. And I'm not sure if that means the supervisors or the zoning commission.
Yeah, I don't think I said that. I'll just rehash what I said, and if this doesn't cover, whoever asked the question, if this doesn't clarify for you, let me know. But what I've said is that new ordinances or changed ordinances or any recommendations around a zoning ordinance originates with the zoning commission. The zoning commission has to have a public hearing, a public meeting, and describe what that new ordinance or republished ordinance or whatever is going to say. They have to have that public hearing. Then, after the public hearing, the zoning commission votes on ultimately what they're going to recommend to the supervisors. When the supervisors get it, before the supervisors can pass any ordinance, they have to go through a public hearing, a public reading. They have to publish the proposal ahead of time, notify everybody in the paper, publish it at the courthouse, and then during a supervisors meeting, they have to pause the supervisors meeting and open it for public comment on this thing that they're looking to vote on, hear the public comment, close the public hearing. If they had a bunch of comments, they should go through a second and third reading. Again, public comments each time. If they only get a couple of comments in the first one, then they can waive the second and third hearing, or second and third reading, and vote on it after just the one public reading. So I don't know, hopefully that addressed your question. If not, if you could rephrase.
I have one that's sort of related to that. The zoning commission has to post or publish the agenda for the public meeting ahead of time so the public knows what will be on that agenda.
That's correct. She's asking if the zoning commission has to post the agenda. Yes, the zoning commission is a government body just as the Board of Supervisors. They're just not an elected body, they're an appointed body, but they have to follow the same state rules, the same state laws. And you have to have the agenda has to be posted to the public in advance of the meeting. If I recall, we publish ours 3 days in advance. I think at the minimum is 24 hours in advance of the meeting. The agenda has to be posted so the public is aware of what is on the agenda, and it is an open meeting rather. An open meeting being that it's a zoning commission meeting, but anybody in the public can attend and listen.
Jeff, could you explain just how many turbines you have in Worth County?
You know, Heather asked me, Kathy asked how many turbines do we have in Worth County, and Heather asked me that question, same question earlier. I've got it on my laptop, I didn't look, but we've got, I think 6 wind farms, wind projects, industrial wind projects in Worth County. A couple of them are nearly 20 years old. In fact, we've got an energy company that might be buying the oldest project right now because it's 20 years old. They might be buying it with the intent to tear it down and put up fewer, taller ones. So I have the count on my laptop. I haven't looked, but just offhand, I would say knowing the general number of the other ones, we're well over 350, probably pushing 400 turbines. You can see a wind turbine from virtually anywhere in the county. And to Kathy's point, looking off on the horizon, it doesn't matter how far away. You see those blinky lights just constant.
Another question?
When you first came up with your draft or what you wanted, how did that come about? Was that I think the questions you're asking is, was that all done at a public meeting when you did all your research and you wrote up your draft that you wanted to present to the public? How did you get that all done? At a public meeting, or did you work on it as a commission on your own? I think I read in your one thing that you had a group, you had different groups you met with or came with and worked on it. Is that right?
Yeah, so basically the question is, how did we come up with the text that is our ordinance that we eventually produced our first draft to the public? How did we come up with that? So yeah, it started off, we actually had a couple of meetings just talking about how are we going to go about this. And I'm fortunate in the fact that I'm retired now. The other 4 zoning commissioners have full-time jobs. So I told them straight away, I'll take on a whole bunch of the behind-the-scenes work and just keep feeding you guys information. So I did a lot of the information gathering and a lot of the initial drafting of text and fed it to them. But we did have interviews with a number of people. In fact, one of our first meetings with the zoning commission was talk about, well, who do we want to hear from? You know, we know much about this stuff as the general person walking down the sidewalk, right? Because we're the general person walking down the sidewalk. And so we need to learn. So who are we going to talk to? So we said, well, we need to talk to the energy companies. They're the ones building them. And supposedly they've got a ton of expertise in it. We need to talk to some conservation folks. We need to talk to our county health people because we hear there's all kinds of problems with these things. And our county is a pretty rural county. You heard we're 7,600 people. So there's a lot of farm ground, a lot of farmers. So let's hear from Farm Bureau. They represent all of these folks. And so that's what we did. Is we sat down and said, who do we want to hear from? And then we contacted these different folks and agencies and said, we want you at XYZ zoning commission meeting on this date at this time to talk about these things, and we want to hear what your thoughts and opinions and concerns and directions are. And so that's how we started.
And those were all public meetings?
Yes, every zoning commission is a public meeting. Now, we were doing ours, as you saw, during some of the COVID crap stuff. So all of our meetings were early on were done via Zoom. In fact, those recordings are still out there on the county website. And we did have people that would listen in. And when we had in-person meetings, and we had several in-person meetings, especially towards the end, we did have people that would show up and watch us and listen to us.
Could you speak to how you address repowering in your ordinance? So starting new, but then how did you address
Yeah, so the question was asking, how does the ordinance address repowering? Which is a good question because, as I said, we've got an energy company that may buy one of the oldest projects in the county for the express purpose of repowering it. So initially, the recommendation, and again, unanimous recommendation from the zoning commission, was that if you're going to repower the turbine, you start over. It's a new project, it's a new permit. Now, if you don't change anything, if all you do is replace some components so that it can continue in operation, and you don't change the physical characteristics of it, that's just operational maintenance. Go for it. But if you're going to change something, if you're going to put bigger blades, different nacelle, tear down the tower, put up a new tower, any of those kinds of things, reused bait, any of those things, it's a new permit. That was our recommendation. The county supervisor said, nah, that's too strict, that's too stringent. They ought to be able to increase these things in size a little bit. One of the supervisors wanted 10%, another supervisor wanted 15%. I think ultimately they settled on 15%. And so we changed the ordinance so that now, I'm pretty sure it says 15%. If they change the physical characteristics of the turbine that changes it by more than 15%, it's a new turbine, it's a new project that goes through the whole permitting process.
There's a question in
Now, back up one question. The question was asked, do those meetings have to be public? And they do, the zoning commission meetings.
Yes.
Did you run into problems where you had a lot of local people that it was hard to conduct a meeting amongst the 5 of you or 3 or 4 of you, whoever were there with a quorum? Were the people there to hear, were they orderly and not blurting out a lot of comments to upset the commission? That's what I think the concern, one of the concerns is.
Sure. I think we're actually pretty fortunate, and maybe it was because a lot of them were via Zoom, so we mute them so you can't hear them. But generally, the in-person meetings that we had, I think people were pretty good. Most of the time, we had nobody that would sit in, or a couple of people that would sit in. And a couple of people very often were the same ones. We'd see them frequently. And they were pretty respectful of the process. They knew that it was not an open public meeting for them to talk. We did have 1 or 2 occasions where somebody would start to say something. Excuse me, this is a zoning commission meeting of the zoning commission members. You're welcome to sit in and listen, but it's not a public participation meeting. And that's all it took. And they said, okay. Now, that didn't prevent people from contacting us as zoning commissioners individually and giving us information and rendering their opinion vociferously or whatever. But yeah, I think most people were pretty respectful of the process. And maybe too, because they could hear the zoning commission members talking about all these different things, and they could hear the differences between zoning commission members. You know, we had a zoning commission member, 2 miles, that ought to be the setback. Well, you know, 2 miles that's a bit far. What are we trying to accomplish? Well, that way you're not going to hear it. Well, but sound is a whole separate thing. Let's manage sound with sound measurements. Let's address sound. We'll get sound to the appropriate level. Now, what's the distance for? Well, the distance is for safety purposes. Okay, well, how far do we need to be? And I think everybody was pretty happy when we come up to, well, a minimum of this much, or X times the height, or whatever the manufacturer's safety recommendations are.
Since you got everything revised, how many windmills have been built, and do you have people trying to come in?
Yeah, so I chuckle because, you know, Invenergy was the ones that precipitated all of this. It was Invenergy that was going to do the project in Freeborn County, didn't like their rules, came into Worth County, violated their verbal promises, and put up a whole bunch of stuff over in Deer Creek and Grove. And they are the ones that want to come in and put up turbines in virtually the entire west half of the county. they were the ones that we were trying to work with to give us feedback on our ordinance. They refused to give us feedback. They instead claimed vested rights. And as soon as our supervisors said, we're not going to sign a separate agreement with you, we're going to pursue our wind ordinance, I think it was 2 or 3 days, their court filing hit the district court saying, we want you to grant us vested rights for the Worth County zoning and Worth County wind ordinance. We hadn't even passed the wind ordinance yet. The wind ordinance didn't even come up in front of the supervisors until a month or 2 after they petitioned the court for vested rights. So that process is on hold. Their other project in that half of the county is on hold until it goes through the courts. There is one other company, though, as I said, that are looking at the first wind farm. It's called Top of Iowa 1. There's a company looking at that. They reached out to me 2-3 weeks ago and said, hey, we're thinking about buying this wind project over here because it's just about run its course, and we're thinking about buying it, maybe tear it down and putting up some new ones. We'd like to talk to you guys and find out what your ordinance is. What's the sense of the county? And so I met with them. They said, yeah, we've read the ordinance, seems simple enough, yeah, we can follow that. Whether they buy it, it goes through, I don't know. But it's just kind of interesting. On the one hand, you get a company that says, we want to be exempted from the rules that haven't even been passed yet. And another company says, well, we read the rules and we can follow that.
So, I kind of feel that the Benton County supervisors went in the direction that they didn't want any, because of the 70% or the CSP or the.
Yeah, I don't know what the land is like in Benton County, if the vast majority of it is high CSR or not. Okay.
Yeah.
So, but, keep in mind too, in the context here, Iowa law says, I mean, it's instituted in Iowa law, this notion of preservation of prime agricultural land. Worth County zoning ordinance from way back when, and our county comprehensive plan, highlight that Iowa law, and that Iowa law and the zoning law in 335. One of the purposes of zoning is to protect prime agricultural land. That's in the code, and so our zoning ordinance says that as well. And so I think it's perfectly acceptable to say, well, our objective is to preserve prime agricultural land. We define prime agricultural land as being CSR 70 or above, and we don't want to take that stuff out of production, so you can't use it for these other purposes. But it's not just you can't use it for wind. It's not just you can't use it for solar. You can't use it for anything but farming. So you can't put a cement plant there. You can't put a tannery there. So it's not discriminatory. It's just saying we're going to preserve this kind of land.
I have a question. Back here, way back.
Oh, yeah.
Hi. Hi. Give your report. 2 questions, actually. First, my question to you is, when you say they've run their course, approximately how old are those turbines that are being replaced?
So the question is, how old are the turbines that I've talked about that are probably going to be replaced? I think they're reaching about 20, maybe 21 years old, something like that.
And have you guys had solar come in and request land, especially land in connection with the turbines?
So the question is, have we had solar projects coming in, especially in conjunction with turbines? To the second part of that, no, we've not had any joint solar and wind turbine projects coming to the county. We have had, I think, 1 or 2 small solar projects in the past. I recall we had just a couple of zoning meetings. Since Worth County, up until this month, only 3 of our townships were zoned. We haven't had a lot of zoning changes. in the county. But I do recall we had one zoning change where the farmer came in along with the energy company that wanted to put a solar farm in on his property. And I don't remember how big it was. It wasn't real huge. We had a public hearing on it. People were concerned about dust and things of that nature from construction, but that was really the only opposition to it. So we approved that zoning change from ag to commercial, I think is what it was going to be for solar. So the question is, if we sign an easement with the wind company and that wind company goes belly up and we're still committed to that easement, frankly, it's going to depend on what the terms of that agreement says. My guess is that the language in that agreement, once you've sold those wind easement rights to that company can resell those rights to somebody else. And if they're going out of business, that's probably one of the things that they're going to do is sell all those easements to somebody else.
If the turbines go in, who's responsible for checking them to make sure that they have put it in according to what they're supposed to do?
Yeah, so the question is, when the turbines go in, who's responsible for making certain that the turbines comply with the rules and stay compliant with the rules? That's a great question, and it's something that your ordinance has to address. And the way we've done it in Worth County, it goes all the way back to the application process. First of all, the ordinance talks about the fact that the energy companies are required to maintain these things up to date. We have a whole complaint resolution process spelled out in the ordinance that talk about notices to the energy company, notices to the public, notices to the Board of Supervisors, and so on. But ultimately, the responsibility to maintain them is the wind turbine, the operator of that wind turbine. And we take it, once again, all the way back to the beginning of the process. When they submit their application, they have to make a whole list, I don't remember how many it is, 15 or 20 individual affirmations on different things that they are affirming that they are compliant with and will remain compliant with for the duration of the project, or their permit can be revoked. And if a turbine is found to be non-compliant, it has to be shut down. And if a turbine is shut down for more than a year, it's considered decommissioned and it has to be torn down. All of that stuff has got to get spelled out in the ordinance. So who enforces the ordinance? Another great question. The responsibility for the enforcement of the ordinance rests with the Board of Supervisors. It's their ordinance. Yes.
When we discussed the mud pads, those developers are supposed to follow guidelines like other commissions.
Yeah, so their permit said they do it, they didn't do it. Supervisors, have taken ownership, or they're saying it's between the landowner and the building company.
Yeah.
The company says the county says that they don't, but they don't do the permit.
Yeah, so if they don't meet the permit, then there should be a process to cause them to be compliant. So Heather's question, and Jack, the basis of the questions here just a moment ago was with regard to the mud pits. And the mud pits being mud pads, I guess you call it, the mud pads being not compliant with the permit that they were granted. And who's responsible for that? What should be done? Well, again, the supervisors, through their ordinance, whether it was the supervisor that signed off on the permit or the zoning administrator, more likely, that signed off on the permit, that start then with the administrator. If they're the ones that signed off on the permit, they're the ones that should be checking on it to make sure it's compliant. If it's not compliant, they should be notifying the entity to whom the permit was issued and saying, make it compliant. I don't care how you do it. I don't care if it's you, if it's a landowner, if it's McDonald's clown. It doesn't matter. You're the permit holder, you're responsible for making it compliant. Make it compliant, there's gotta be something in the ordinance or the permit that gives them a certain timeline that they're supposed to cure that stuff. If they don't, there should be something in the ordinance. I believe there's something in the zoning ordinance, that they can be fined. I think it's $750
So we don't have any of that in ours. We have nothing.
No, I think you do.
On the complaint process?
I think there's something in their zoning ordinance that talk about, non-compliance. I'll look.
I think they're supposed to deal with it. I don't know that there's money on it. I can't remember.
Yeah, I thought I had read the fine, maybe I'm thinking of ours.
Okay.
But, yeah, there should be, and that's another thing that's important. If your ordinance doesn't have teeth, if there's no, compliance mechanism, permits are just about worthless. They should have expirations, and there's got to be teeth that cause them to be compliant. And if the zoning administrator or the board of supervisors, because ultimately it goes to the board of supervisors, it's their ordinance, they are the legislative body of the county. If they're not causing things to happen that are by statute supposed to happen, and your ordinance is a statute, if your supervisors are not enforcing their own statute or causing the enforcement of your own statutes, I believe there's legal recourse. I don't remember, there's a writ of something that essentially is a petition from a citizen to the court saying this government official is not performing his government duties as written by statute. Please require this government official to perform their duties as required by statute. It's an obligation.
We had a question out here. Ruth?
Yeah, I wondered, did you set up any rules for decommissioning the towers when they're reached their, their 20 years or whatever?
Yeah, so the question was, did we set up rules for decommissioning? We did. And I think it was Heather's or Kathy, one of them talked about your current ordinance talks about 15 years down the road, maybe there's escrow that they have to put in for that. So we cover all of that stuff in our ordinance that talk about how they have to submit a third party set, so a set of plans written by a third party that talk about how much it's going to take to decommission these things, and then they have to submit a certain amount of escrow to decommission them. And it describes that they got to take these things down, take them away, they got to repair all the drainage, repair any roads, and we require that they take the land, they take the concrete down, they remove everything down to 6 feet. Most of the ordinances that you see that talk about decommissioning, and which, by the way, the wind companies will tell you they'll do, is 4 feet. Recall early on I said that we had interviews with all these different agencies, and Farm Bureau was one of them. The Farm Bureau rep that we had interviews with early on in our process said 4 feet is not far enough. They need to take it down to 6 feet. Our crops are growing that far. They go that far to seek moisture in dry years. So our ordinance requires they take it down to 6 feet.
I have a question. I was wondering if you could touch on what are the hazards of the turbines to people and to wildlife?
So the hazards, what are the hazards of turbines to people and wildlife? Like I say, there's excuse me, there's a great number of them. Kathy talked about a couple of them. The shadow flicker is, that causes people nauseous. We had people that sent us copies of a video that they took from inside their home. A lot of times, the energy companies will say with regard to shadow flicker, you're only going to get 30 minutes a day, maybe 50 hours a year. It's not that big a deal. Close your curtains. They sent us a video in their living room with the blinds closed, and you watch the shadow go across 3 rooms of the house through those closed blinds for 30 minutes. He says, it drives my son nuts. He can't be in the house. He's got to go out back.
Is that just at night?
No, that's sunrise and sunset typically. It's when the sun is low on the horizon. Well, it doesn't have to be very low for a 600-foot turbine, but when the sun is shining, when the turbine is between you and the sunshine, you're going to get that shadow. And it's like a strobe. You know, it's just a constant in front of your eyes at whatever speed that turbine is spinning. So that's one of the effects. She talked about the infrasound is another one. The people complain about the audible sound, and there's multiples. There's sounds from the blades that go around, and there's sounds from the motors inside. Well, some of the sounds, the infrasound, is really, it's just sound that is below the threshold of human hearing. We can only hear sounds so low. You know, you've heard them talk about elephants, you know, talking very, you know, they rumble in very low frequencies, and that sound can travel for miles, and they say, people, that you can't hear it, but you can feel it. That's infrasound. It's sound that we can't hear, but we can feel. It's real, and it affects some people. What percentage of people? Not a large percentage, but does it matter? If our job as officials are to protect the rights of the citizens, am I supposed to single out the people that are susceptible to this and say, we're going to sacrifice you? No, your ordinance has to address those things. With regard to animals, I think the biggest thing, wind turbine effect on animals is bird strikes and bat strikes and bees and, you know, whatever else. And the U.S. Fish and Wildlife have rules that the turbine manufacturers are supposed to follow for environmental studies. And Iowa DNR requires them to submit their plans to the DNR for the DNR to review and make recommendations. The problem is that Iowa DNR recommendations are only recommendations. And the energy company can look at the recommendation and say, yeah, no, we're not going to do that. And unless your ordinance says, yeah, you got to do that, they don't have to. U.S. Fish and Wildlife says they have to conduct certain studies, and if there are endangered species or eagle nests within certain proximity, then they have to do additional studies, and they have to have an eagle take permit and have a hazard mitigation plan and things of that nature. But you know, unless you require it as a part of your application, half of the time that stuff is never done.
We have eagles in Iowa. I have seen them.
Oh yes, we have multiple eagle nests, documented eagle nests in Worth County. Iowa DNR recommends a 5-mile buffer from an active eagle nest for wind turbines. Iowa DNR maintains a map of known active eagle nests. So you can go on the Iowa DNR website and go through and find it, and it will show you where are the known active eagle nests in Tama County. And if there's an eagle nest over here that's not on the DNR map, you can submit the paperwork and say, there's an eagle nest there, here's the evidence of the eagle flying in and out of it, here's pictures of little babies poking their head up out of the nest, and get that nest added to the map. Now, that Iowa DNR recommendation of 5-mile buffer for eagle nests, I can tell you the wind companies don't like that, and they don't adhere to it. They just disregarded it in Worth County in their plans to us. Our ordinance gives them a required buffer. And our ordinance says, whatever recommendations the DNR gave you, you have to show us that you're following those recommendations or explain to us why you shouldn't need to follow those recommendations and what are your mitigations. And that's part of the permitting process.
With that many turbines in your county, have you noticed people moving out of your county?
So the question, with as many turbines as we have, we've noticed people moving out. We've noticed people moving out, and we've noticed people not moving in. We had people contact us when they found out that Invenergy was talking about the Worthwhile Wind Project in the west half of the county. There were people that were in process of buying land in Worth County that found that there were going to be a turbine X far away, according to the energy plan, and said, I'm not buying that.
Also, land prices going up or down.
Well, land prices in general are going up all over the state of Iowa. But as far as homes, it does affect the property of homes. There's a number of studies out there. I think, I hesitate to say because I'm not certain it's Michigan, but I believe Michigan has a study not that long ago that looked at home price values in proximity to turbines. Now, the energy company will tell you that a turbine on the property is going to increase your value because that's guaranteed income. Well, for the land that the turbine is sitting on, that's probably true. But for the house 800 feet away on the other side of the property line, that is absolutely not true. That person's going to have a hell of a time buying that property or selling that property because nobody's going to want to move in 800 feet from the turbine. Yeah, so the question is, those blades being airfoils, if a tornado goes through a wind project, what's going to happen to the blades? If the blade becomes detached or broke, it's flying. And that's part of that safety distance that I referred to in the manufacturer's documents. Because they talk about how far you should evacuate the area if there's a fire, how far you should evacuate if there's lightning in the area. Thunderstorms, windstorms, they describe all of that stuff in there. ISU has done studies. Kathy talked about the ice throw a little while ago. Ice throw is a real thing. We're talking chunks of ice, not small little pieces. We're talking about a 50-pound chunk of ice flying through the air. And Iowa State University has done studies, and they found that stuff goes, I don't remember the distance, but it's a phenomenal distance that ice gets thrown. The speed that those turbine blades are spinning at the tips are much faster than what you think it is. I don't know if anybody has that.
200 miles an hour.
200 miles an hour. That tip is flying. So imagine if I've got a 50-pound chunk of ice in my arm and I swing that thing 200 miles an hour off into the distance. It's going for a ways and it's doing some damage. And it's one of the reasons why our wind ordinance in North County says that they have to have anti-icing built into their turbines, and ice detection built into their turbines. And if they detect ice on the blades of the turbine, they're required to shut that turbine down until there's no ice present. I haven't. I'm sure they probably have, but I'm not personally aware of it. Yeah. Well, I know just as I said, we've had at least 3 wind turbine fires in North County that I'm personally aware of. And I know that in one case, a lady had gone out and videoed and measured the distance that pieces of the blades, because the blade's fiberglass. The fire starts up in the nacelle, that blade's melting. And whatever wind is happening is just carrying pieces off. In some cases, she reported pieces of burned material that were over 1,000 feet away. And in some cases, just whole pieces that have become detached that the wind had carried. Yes?
If this is such a good deal, why is our government subsidizing this
So I'm going to guess by the applause, most of you heard the question. Why, if this is such a good deal, why is the government subsidizing this stuff? It's a great question. I think there's certain politicians and certain parts of political parties that are just convinced this is good stuff. And the only way that's going to change is vote.
We got a lot of coal, and we got a lot of natural gas.
Yep. Yeah, and I can tell you, there's a lot of times where those wind turbines up in North County are spinning pretty good, and there's other times where they're just sitting down. They're not generating any electricity. Yes?
How are they gonna dispose of those damaged blades?
How are they going to dispose of the damaged blades? That's a great question. I saw, in fact, I don't know if it's still there, probably last year sometime, shortly after I read an article about the problems that they're running into now decommissioning these wind turbines. Shortly after that, I was driving down Interstate 35. Come to find out, Iowa was one of 3 places that they were shipping turbine blades to from these decommissioned turbines because they can't get rid of them. They're made out of fiberglass, and they don't have any way to recycle them. So what they're doing is the metal towers, those can be torn down and sent in for recycling. The blades and the shell of the mesa, that power unit that sits on top, that's fiberglass. And they don't have any way to cost effectively recycle that fiberglass. So what they're doing is they're chopping them up into sections that are easy to transport on the highway. And one of the destinations was Iowa. There was a spot right up on 35 where there was a boatload of them, chopped up turbine blades, stacked up over here somewhere, waiting to be shipped off to a landfill so that the landfill could crush them up and bury them. But they were having problems with that because of the shape, as they pointed out, their airfoils, the shape of these fiberglass turbine blades are such that when you start stacking them on top of each other, those slippery buggers start sliding all over, so they can't get up on top of them to crush them. Yes? So the question was, did I cover what Worth County is doing with the money that we're receiving from the energy companies? No, I didn't cover that. And it's actually a very strong topic of debate in Worth County right now. In the past, so let me back up a little bit. When a wind turbine comes in, there's 2 ways that the county are going to receive tax money from that turbine. One way is through a utility tax. Now, the county gets to decide which way they're going to go. The county can say, we'll take it through utility tax, in which case the state of Iowa will determine what energy that project is generating and what those taxes should be, and then the tax money will filter through the state to the county. The other way the county can do it is the county can say, we don't want to go that way, we're going to value it the other way. And the other way that Iowa law says they can value it is for the first, I think, 5 years, the taxable value, or the taxable value of that turbine is 0. The next year, year 6, is 5%. And it's 5% of the value that the wind turbine company says is the value of the turbine. So let me repeat that just backwards a little bit. The wind company, according to Iowa law, will say, here's how much this turbine is valued at. On year 6, the county can tax that company 5% of that value. Each year, it raises by another 5% until whatever year it is, you have to do the math. When it reaches 30% of the value that the wind company says it is, it caps. And that's how much tax the county will get from that turbine. Now, a lot of counties, Worth County being one, the county supervisors look at that future tax and go, hey, that could be a chunk of change. But, we got projects now. So let's tip it. So TIF if you're, just a brief dissertation on TIF. TIF is tax increment finance. TIF is designed to say, if I'm a developer, and I'm gonna come into Toledo, and I'm gonna build this huge new facility, and employ gobs of people, and I'm gonna take this derelict property, I'm gonna put this facility on this derelict property. But, you know, I don't have all the cash right now, so I want the county to work with me and come up with some money to help pay for that in exchange for future taxes. Because the tax value of this abandoned property, right, this derelict property, the tax value is low. I'm going to increase the tax value by building this thing. So the county can effectively go out and get a loan on the presumed incremental increase of taxes that they're going to get in the future to help that project. That's what TIF is for. Now, a lot of the counties, Worth County being one, is looking at the wind turbines and saying, well, that's going to increase in tax, or that's going to give increased tax value, so we should be able to take a loan on that. And so they do. So they take a big loan out now for the next 10 or 20 years that will be paid for out of those taxes. And that loan has to be used for a specific one or two thing project that they have to specify today. And that's how Worth County's been spending that money. Well, if they sell out, somebody else is still operating the turbine. And so the value, the taxable value of the turbine is still the taxable value. But the taxes that you get 15 years from now isn't coming into the county budget for general use. It comes into the county budget to pay off the loan that the county took 15 years ago for that road project. Yeah, so the question is, can I speak to the county roads and the destruction of the county roads? If you talk to our county engineer will tell you that the road system in Worth County is one of the best in the state, the county roads, the primary and secondary roads. And I would tend to agree with him that they are generally in very good shape because they've been tipping the crap out of all of those wind turbines and building road projects left and right. And the wind companies have had, generally speaking, we've had a pretty good experience with the wind companies. When they first come in, they'll do a survey with the county engineer, say these are the roads that we're going to use. In some cases, they have to cut a corner, across this farmer's field to put in a larger sweep turn to get these turbines in. And the wind company will put all that stuff in, they'll manage the drainage, they'll reseed everything, and they'll maintain the roads, and then when they leave, they'll tear out those extra ones and things of that nature. So they've generally been pretty good about that, but at the same time, we've had agreements on that. And like I said, we've had 5 or 6 projects that are in place now. So I think our county engineer has learned a lot of what should go into those agreements. And we strengthened that a little bit in our ordinance, but that's the key, is to make certain that before the permit is even issued, they have to agree to these kinds of terms and do the surveys ahead of time, manage it. You have to have a process in there whereby citizens can complain about things and how those complaints are adjudicated, how much time the energy company has to resolve things, dust control, all of that stuff.
So Jeff, how often are you going to review the wind energy ordinance from here on out? Is it required like every 5 or 10 years? Are you going to look at it yearly, like in case it's a really good one for your county, which is good, but there still could be technology and things that change. So how often are you going to review
so the question,
it?
how often are we going to review the wind ordinance and potentially change it? We should be reviewing ordinances. If an ordinance is on the books, there's no ordinance that is managing this level of detail that should go beyond 3 years before somebody takes a concerted look at it and say, what have we learned over the last 3 years that may need to update? Now, presumably, as things come up, as things are highlighted through experience, you're going to make incremental changes. But incremental changes aside, I think there should be a formal process where every 3 years you're doing a comprehensive review and saying, okay, is this still adequate? Do we need to make changes?
Well, that's good to hear. We were 12 years and the wind farm was approved at year 10, so, and they weren't reviewed for 12 years, so.
Right. Yeah, and a lot of it is, it's sight, out of sight, out of mind, right? If it's not been used, if there hasn't, the ordinance has been there for 10 years, but there's not been any projects, it's just sitting on the shelf, out of sight, out of mind. And we're guilty of that in Worth County. I discovered that when I became chair of the zoning commission, I started looking into this stuff a little bit more, and one of the things I found is that our comprehensive county plan is supposed to be reviewed on an annual basis by the zoning commission, and then update recommendations made to the supervisors. Our county plan is dated 2006. I've been on the zoning commission for probably 10 years. I don't remember the chair ever bringing it up for review. It's on our agenda now. We're going through, in fact, we're going through a massive review because the plan is old. It doesn't say anything at all about turbines, or it says we want to preserve land, we want to preserve conservation areas, and blah 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 blah. How well have we done? I don't know. That's part of what we're reviewing now.
Does your ordinance address solar as well as wind?
No, the ordinance, our zoning ordinance talks about solar, but it's pretty weak. And we have on our agenda to either update language in the zoning or create a separate solar, not sure yet. But what was recently passed in June for the wind ordinance was just purely wind turbine.
Any other questions for Jeff?
Just one. Do they hire local employees, or do they bring in their own crews? The pitch was that it would be beneficial for employment, for local young people.
Yeah, I think it's some of both. They'll hire some of the early management of the operators, because what will happen, I can't say this will happen, what frequently happens, and if it's a company like Invenergy, their business model is to come in, go through the application process, get the permits, and immediately sell the project for somebody else to implement. Very often, the company that implements the project, as soon as they get it implemented, they turn around and sell it to another company that's going to operate it. So, the first energy company, they're not hiring a handful of people, and those are the land agents that are going around stretching things to try to get people to sign easements. The company that comes in that's going to build it, they're going to hire some people local, but most of them, they're coming from outside. Because it's a big energy, it's a big company that specializes in building these things. And so they just hopscotch from one project to another. The operators, when they take over the operation of it, they'll hire some people local that's going to maintain it. And they'll set up a little shop somewhere, they'll have an office, they'll have some of their folks will come in from somewhere else initially to start the operation, training some local folks to take over the operation. And they'll hire local folks to train them to do the maintenance, to be up in the towers and climbing and doing things of that nature. Those will be some local folks that are doing the general maintenance. And then for the specialized stuff, then they'll bring people in from outside again. So there's a few that get hired locally.
Do you work well with your zoning administrator? Because I think here in Tama, we kind of depend on zoning administrator.
Yeah, so the question is, do we work well with the zoning administrator? And Tama County seems to depend on the zoning administrator to initiate things. I think that last statement is probably true for a lot of the rural counties, and maybe even some of the larger counties as well, where there's a dependency on the zoning administrator. And I think historically in Worth County, at least for the 10 years that I've been involved, that's been true, that there was a dependency on the zoning administrator. And again, not trying to make an excuse, but we had 3 of 12 townships that were zoned. We got very few requests to change zoning, from here to there. And we're just appointees. Joe off of the street, do you want to be a zoning commissioner? Sure, why not? I can read. And there was a dependency on the zoning administrator to initiate things. When I became chair, when I was asked to be interim administrator because our administrator passed away. And so that's when I first dove into it. And I dove into it reading state law, reached out to ISU to get some training, read through our ordinances, read through our plans, and went, oh crap. Zoning Commission's supposed to have been doing a whole bunch of this stuff all along. We haven't been doing it. And why do we only have 3 of 12 townships that are zoned? That's not fair. And so I raised those things to the supervisors. And then it was just in 21 that I was elected as chair of the commission, actually at the beginning there. And that's why I said, well, I could read, I see what this stuff says, so it's the responsibility of the zoning commission. If you read the duties of the zoning administrator, the duties of the zoning administrator is to process the applications, manage the permits according to the ordinance, and act as secretary for the zoning commission. That's the duties of the administrator. The duties of the zoning commission are to draft and recommend ordinances, etc., related to zoning. And I think there's a lot of us that get started in this stuff don't realize that, crap, this appointment job seems to have a lot more responsibility for this stuff than the zoning administrator, that we've been counting on all this stuff. It's not the zoning administrator's job to originate these things. Part of it's just education. Yes? Somewhere there. That's not an exact one. I'd have to look at my laptop and look at the different forms. Oh no, those have been going in since 2000. Yep. Yeah, there's very few of them. Very few of the turbines in North County ever had to have a permit. Well, I really, as I said, I got deeply involved in the middle of 2020 when they said, hey, we want you to be the zoning administrator for a little while because our zoning administrator just passed away. And I've been on the zoning commission for a number of years, and I said, yeah, okay, I know that she hasn't processed very many permits, so yeah, I could do that. And that's when I started reading and finding out what was supposed to be happening. That's it.
Thank you. Thank you, Jeff. We're very fortunate to have somebody with his knowledge come down and speak to us, and I think it was a tremendous learning experience for all of us tonight.